The Democratic Alliance says its application to review Brian Molefe's reappointment as Eskom CEO will proceed, even if Molefe's Labour Court urgent application succeeds. The opposition party says a court order will be taken preventing Molefe from performing any duties that are subject to the completion of his Labour Court matter. The DA also indicated it intends to intervene Molefe's urgent court application. Brian Molefe approached the court on the grounds that his appointment was rational and that the Public Enterprises Minister Lynn Brown only set his reappointment aside for political reasons. However, the DA says that Molefe's court action is nothing more than desperation. Former Eskom CEO Brian Molefe's urgent court bid is not on the court roll today. Molefe wants the decision to remove him as the Eskom CEO declared invalid. Molefe served papers on both the Power Utility and Public Enterprises Minister Lynn Brown. The minister's office received the papers and her legal team is studying the documents. Molefe returned as Eskom CEO on the 2nd of May after he served 3 months as a Member of Parliament. However, the decision was rescinded on Friday by the Power Utilities Board. Dr. Ben Gubane, the chairperson of Eskom's board, says that this was in line with Brown's instructions on the 31st of May. Now, in his court papers, Brian Molefe says his dismissal is unlawful and unfair. He says only the minister and not the Eskom board has the power to remove him as the group CEO, as per clause 14.34 of the Memorandum of Incorporation. Molefe says his dismissal is required to be effected in terms of Section 186, subsection 1A of the Labour Relations Act, and that summary dismissal cannot be imposed on him. He says there is no legal basis for his dismissal that is based on his conduct, his capacity or operational requirements. Molefe argues that his dismissal by Minister Lynn Brown was motivated by political considerations which do not amount to lawful grounds. And finally, Molefe says in entering the reinstatement agreement, Eskom elected to honour his March 2016 contract of employment and in so doing divested itself in any rights to dismiss him.
We did receive the papers, and our legal team is busy then pouring over those so that they can derive our own response. So that is essentially going to be the case that then in terms of the challenge, we need to actually find a way of responding to that. That's what we are busy with. Right now, we are working, in tandem with, the Labour Court to make sure that we deposit our response in time, relative to whatever could be the timetable in that regard.
Molefe asked the court to hear his application urgently due to the DA court bid that is coming up tomorrow, that is the 6th of June. He goes on to say, and I quote, "Significant costs and time have been dedicated by myself in opposing the DA's application. The current status quo will effectively kill any prospects of opposing the DA application." Molefe says he needs his employment status restored to effectively participate and to oppose the DA's application that is set for the 6th of June. That's on Tuesday.
The law is on his side. The best way was for him to have approached the courts to ask them to interpret what the legal provisions are and what powers the African National Congress would have had to instruct the minister to rescind an appointment when the minister does not even enjoy the legal privilege to have instructed the board of Eskom to do what it did. And therefore, I mean, these are operational matters, and it was not their legal privilege to interfere or intervene, for it is unlawful. Why they even thought that they could do it, it is baffling, said to say that it only confirms the Democratic Alliance's long-standing accusation.